The Supreme Court has issued a ruling so impactful that it has completely upended Donald Trump's legal framework, plunging the former president and his attorneys into unprecedented turmoil. Observers are witnessing a pivotal moment in American jurisprudence, one that few predicted, with consequences for Trump's defense strategy that are potentially devastating. In a decision scholars are already calling unparalleled, the highest court commanded Trump to deliver financial records, private corporate communications, and classified documents previously unknown even to his legal team. This action was far from ordinary. The Supreme Court dismantled a protective barrier, unveiling evidence long concealed from public scrutiny. A secret grand jury proceeding had been running alongside every known case for over a year, entirely hidden from view. Trump now faces a legal obligation to produce materials that may expose entirely new criminal dimensions. What makes this remarkable is the extraordinary secrecy maintained throughout the process. The entire judicial maneuver occurred outside media coverage, unnoticed by the public and without the knowledge of Trump's lead counsel until the verdict was released. No prior notification, no televised arguments, no press updates. His communications and legal teams had no time to craft responses or defensive strategies. One moment, Trump assumed he understood every existing threat. The next, the ground shifted beneath him, revealing vulnerabilities that had never been apparent. This is not merely an addition to his expanding legal challenges. The Supreme Court's revelation of a hidden, ongoing investigation involves highly sensitive evidence potentially catastrophic if disclosed. The existence of the subpoena remained fully classified, a detail that dramatically alters our understanding of Trump's legal exposure and political trajectory. This revelation could fundamentally redefine how the former president's vulnerabilities are perceived. To grasp the magnitude of this unexpected Supreme Court intervention, it is crucial to recognize how extraordinarily uncommon such secretive actions are. Ordinarily, the Supreme Court functions with maximal transparency. Cases are listed on public dockets, allowing open tracking. Oral arguments are announced months ahead, providing ample preparation time. Legal briefs are submitted openly for examination by journalists, scholars, and the general public. Confidentiality is typically the exception, not the norm. However, in extremely rare and narrowly defined circumstances, the court can conduct proceedings entirely in secrecy. This authority is reserved for situations involving national security or other extraordinary risks where public disclosure could cause irreparable damage. Historically, this power has been deployed sparingly, often limited to intelligence matters or sensitive operations. The invocation of this authority in Trump's case underscores the severity and significance of what is at stake. According to the December 7th ruling, the sealed process began more than a year prior, triggered by a grand jury subpoena seeking comprehensive financial documents, internal communications, and materials linked to issues described as being of significant national concern. Because the subpoena was issued under seal, Trump received it while simultaneously being subjected to a gag order, legally forbidding disclosure to the public, his supporters, or the media. His attorneys were bound by the same strict confidentiality rules. What makes this situation extraordinary is that Trump challenged the subpoena using sealed filings, advancing the same immunity and executive privilege arguments he has publicly asserted. Despite deploying familiar legal tactics, every attempt failed at each judicial level. The case advanced through the federal system entirely outside public scrutiny, leaving both the press and citizens unaware of this hidden legal battle. The lower court dismissed his arguments, and the appellate court upheld that decision. Now, the Supreme Court has issued a final unambiguous ruling revealing the hidden proceeding and mandating immediate compliance. Chief Justice John Roberts authored the opinion, which is clear and uncompromising. It specifies that the subpoena demands materials concerning actions entirely outside any claim of presidential immunity. Furthermore, all attempts to delay or obstruct have been exhausted, and no further postponements will be allowed. Legal analysts highlight that this investigation is entirely independent from the Florida classified documents case, the January 6th prosecution in Washington, and the Georgia election interference inquiry. Effectively, it represents a fourth major legal front that emerged without public awareness. While Trump has faced prior Supreme Court defeats, this ruling is exceptional due to its element of total surprise and the disclosure of a previously hidden dimension. Earlier immunity rulings were anticipated. The legal team had time to prepare alternative strategies and public messaging. The 2020 decision allowing New York prosecutors access to tax returns was similarly expected, unfolding publicly over years. Even historic cases like United States versus Nixon provided forewarning and time for consideration. This current situation is structurally distinct. Trump's attorneys had no knowledge that this sealed proceeding had escalated to the Supreme Court in this form. No preparation, no contingency planning, no opportunity to anticipate the consequences existed before the ruling landed. Trump's legal team had no chance to anticipate this outcome. They started the morning assuming they fully understood the extent of his legal exposures, only to discover by midday that their assessment was entirely inaccurate. According to December 7th, reporting from the New York Times, the lead attorneys learned about the Supreme Court ruling through breaking news alerts rather than formal court communication. The sealed nature of the proceeding restricted even standard procedural notifications. Sources described the scene at Mar-a-Lago as chaotic, with lawyers urgently trying to identify which records were subject to the subpoena and the precise timeline for compliance. Historically, Trump responds to setbacks by attacking. He criticized justices after immunity rulings, filed immediate appeals when lower courts ruled against him, and dismissed incriminating evidence in classified document cases as fabricated. His consistent strategy has been confrontation, delay, and delegitimization. This ruling, however, leaves virtually no room for evasion. Every judicial avenue has already been exhausted. The Supreme Court's decision is final, with no remaining appeals or higher authority to challenge. Compliance is required within exactly 72 hours. There is no extension. The court issued a strict warning. Failure to respond fully and in good faith could trigger immediate civil and criminal contempt proceedings, including possible pretrial detention. Any attempt to delay, obstruct, or provide partial responses risks incarceration before trial. The language reflects a judiciary at its limit. Justices have observed repeated attacks on judges, disregard for court orders, and politicization of the legal system. This decision signals that such behavior will no longer be tolerated. So, what does the sealed subpoena actually demand? Why has Trump's team descended into panic? The answer lies in the unprecedented scope of the requests. Excerpts from the public ruling indicate prosecutors are seeking three broad categories of evidence, each with potential to expose new areas of liability. The first category demands a comprehensive set of financial documents from Trump's corporate network going back to 2015. This includes all dealings with foreign entities, loan contracts and their terms, and correspondence concerning property valuations. These materials could illuminate long-standing allegations of financial misconduct and potential money laundering, claims that have followed Trump for years but have never been fully proven in court. Second, prosecutors are seeking every communication between Trump and certain foreign nationals whose identities remain redacted for national security reasons. These interactions go beyond ordinary business matters and may involve discussions with foreign governments or intelligence-affiliated individuals. Analysts speculate this could include communications with Russian oligarchs or undisclosed contacts with officials during or after his tenure in the White House. The third category is perhaps the most explosive. It targets documents regarding efforts to solicit or obtain resources from foreign sources in connection with electoral activities. This closely aligns with federal statutes prohibiting foreign contributions to U.S. political campaigns, raising questions about whether Trump or his team sought or received illegal assistance, a serious threat to the integrity of democratic processes. Trump's legal defense faces a nearly impossible task. While some materials intersect with ongoing investigations, the subpoena expands far beyond previously known cases. Financial records may touch on existing civil fraud claims, but could also reveal entirely new allegations. Foreign communications might overlap with prior inquiries. Yet, the involvement of classified information implies far greater stakes. His attorneys have only 72 hours to locate and submit documents covering nearly a decade of complex business and political operations. The full scope of materials may not even be known to them. They must review potentially millions of pages for privilege issues while fully aware that the court will not tolerate delays. According to reporting from Politico on December 7th, Trump's team convened an emergency meeting immediately upon learning the ruling, confronting what one source described as a near insurmountable logistical and legal challenge. Within hours of the ruling, Trump's legal team held an emergency session to assess what one attorney called an impossible task. The sheer volume of requested documents is staggering. The deadline is unforgiving, and the consequences for failing to comply include potential imprisonment. Yet, the logistical hurdles are only part of the risk. The far greater danger lies in the contents of the materials themselves. What Trump spent a year fiercely defending in secret litigation now teeters on the edge of public exposure. The extreme confidentiality surrounding the investigation strongly indicates that prosecutors consider the evidence profoundly consequential. Multiple reports, including coverage from CNN and MSNBC, describe Trump's reaction as explosive. Sources say he yelled at his lawyers, threw objects, and demanded to know who allowed this covert proceeding to advance unchecked. There was no betrayal involved. His attorneys had fought the subpoena at every judicial level, but were legally barred from discussing the case publicly. The secrecy Trump often leveraged to control the narrative backfired. He could not rally public support for a battle the nation was unaware of. Predictably, he escalated tensions on Truth Social, attacking Supreme Court justices, including those he had appointed, labeling the decision a covert assault by corrupt judges. He questioned Chief Justice Roberts' impartiality, declared the entire proceeding unconstitutional, and stated he would refuse compliance with what he called an illegitimate order. Legal experts immediately warned that these public statements could serve as compelling evidence of intent to defy a lawful court directive. Should Trump follow through on his refusal, prosecutors could point to these posts as proof that non-compliance was deliberate, not the result of procedural complications or good faith disagreements over the subpoena's scope. Former federal prosecutor Andrew Weissman, speaking on MSNBC, noted that openly declaring an intention to ignore a Supreme Court mandate is effectively a written invitation for contempt proceedings, leaving Trump exposed to immediate legal consequences. In this scenario, prosecutors don't need to prove intent. The defendant has already made it clear publicly. Trump now faces a situation where every possible choice carries severe consequences. Compliance with the subpoena would hand over documents that might reveal previously unknown areas of legal vulnerability. Anything he has tried to conceal could soon enter the official record. On the other hand, refusal to comply triggers immediate contempt proceedings. The Supreme Court has explicitly warned that penalties could include pretrial detention. The reality is stark. Trump could end up behind bars, not for existing charges, but for defying a lawful court order. This unprecedented situation would mark a historic spectacle. A former president incarcerated for contempt while multiple criminal cases remain unresolved. Attempting to buy time through procedural tactics is nearly impossible under the 72-hour mandate. There's no window to file new motions or pursue further appeals. The Supreme Court has made its final ruling. Compliance is unavoidable, and the consequences are of his own making. The documents could have been provided over a year ago when the initial subpoena was issued. But instead, he contested it at every stage, losing repeatedly and wasting valuable time while the evidence remained inaccessible to prosecutors. Now there is no remaining path for delay or avoidance. This revelation has sent shockwaves through Trump's political and legal networks. The existence of a previously secret proceeding raises urgent questions about what other investigations might be operating out of public view. According to the Washington Post on December 7th, allies are scrambling to assess whether additional sealed cases exist. If one investigation could advance to the Supreme Court undetected, others could be in motion as well. The uncertainty is a psychological blow to Trump's defense strategy, which had been meticulously built around known cases. Trump's legal team had been operating under the belief that they fully understood the scope of his legal battles, covering known matters such as classified documents January 6th and cases in Georgia and New York. They allocated resources, designed strategies, and synchronized timelines based on that assumption. Now it's clear that belief was dangerously incomplete. Chaos intensified when reports surfaced that at least two attorneys are considering stepping away from the case. Sources cited by CNN indicate these lawyers were not fully briefed on the sealed proceeding due to confidentiality rules. They are now questioning whether continuing representation is ethically viable if critical information was withheld, or if their own professional responsibilities could be compromised. Any withdrawal at this stage would create a logistical nightmare. New counsel would need months to understand the intricacies of the matter. Yet the Supreme Court's 72-hour compliance window does not pause for staffing changes. Given Trump's already strained reputation in the legal community, securing capable replacements would be exceptionally difficult. Meanwhile, the attorney who previously cooperated with prosecutors providing leaked audio recordings is reportedly offering further insight into the sealed subpoena. Sources familiar with the case cited by Politico say this cooperating witness has detailed knowledge of documents Trump allegedly tried to hide and can testify about discussions regarding potential consequences if those records became public. If accurate, prosecutors now possess more than mere subpoena authority. They have a precise roadmap. Investigators can cross-check Trump's document production against this testimony. Any missing materials or irregularities would be immediately apparent. This raises a critical question. What does this surprise ruling reveal about Trump's broader legal vulnerability? Its implications reach far beyond publicly known matters. The demand for extensive financial record signals that prosecutors may be building a case that goes well beyond existing fraud allegations. While the New York civil fraud case focused on inflated property valuations, this inquiry appears to target a much wider spectrum of potential misconduct. The financial record subpoena goes far beyond routine scrutiny. While previous investigations focused on property valuations for loans and taxes, this inquiry reaches back to 2015 and encompasses every transaction with foreign entities. Legal analysts suggest this signals a far deeper investigation, possibly touching on money laundering, undisclosed foreign income, or violations of the Foreign Corrupt Practices Act. Tax law experts speaking to CBS News described the breadth of the request as extraordinary. Typically, prosecutors limit subpoenas to specific deals or short time frames. Requesting nearly a decade's worth of records from all international dealings points to an effort to uncover systematic patterns rather than isolated incidents. The second area of focus, the demand for communications with redacted foreign nationals, raises serious counterintelligence concerns. The court explicitly invoked national security to justify keeping these identities secret, unusual language that implies potential links to intelligence services or ongoing investigations. Some observers connect this to long-standing questions about Trump's interactions with foreign governments, his unusually differential approach toward leaders like Vladimir Putin, private meetings without U.S. officials present, and his handling of classified information in conversations with foreign nationals. These questions have never been conclusively answered, but this subpoena could finally generate documentary proof. Finally, the request regarding the acquisition of things of value from foreign sources tied to electoral activities signals a potential campaign finance probe on an unprecedented scale. Federal law strictly forbids foreign contributions to U.S. political campaigns and prohibits campaigns from soliciting or accepting such funds. If Trump or his team received or requested assistance from foreign entities, it would constitute a major federal violation. Campaign finance specialists interviewed by MSNBC note that the ruling's language mirrors statutory prohibitions almost verbatim, indicating prosecutors are zeroing in with precision, not ambiguity. The scope of the subpoena suggests prosecutors are seeking documents to clarify and expand ongoing investigations. The requested materials, including financial records, communications, and other sensitive information, highlight the seriousness and complexity of the case. This is not just another routine legal matter. It underscores the challenges involved in navigating highly confidential judicial proceedings. Legal experts have emphasized that this ruling is extraordinary due to its secrecy and urgency. Scholars note that such measures are extremely rare and indicate the court viewed the situation as requiring special handling. Observers also recognize that the speed and scope of the compliance deadline create unprecedented pressure for any legal team. The ruling demonstrates the high stakes involved when top-level judicial authorities take decisive action. It is a striking example of how the legal system can operate under extreme confidentiality while maintaining the rule of law. This case is now a focal point for understanding procedural rigor, accountability, and the balance between confidentiality and transparency in major investigations. What exactly do authorities know? How long have national agencies been investigating? And what have they discovered? Many of these questions may never be answered publicly, yet they underscore the significance of this ruling. This situation is not just about an individual facing legal scrutiny. It reflects the delicate balance between national security and judicial procedures. The judgment introduces major uncertainty into the political landscape. Trump, currently leading in Republican primaries, faces a scenario that requires legal compliance. Supporters may interpret this as overreach or persecution, while others may question what is being investigated and why secrecy was necessary. Recent polling indicates a significant portion of the public believes all citizens, regardless of position, must adhere to lawful requests. Observers note that this reinforces the principle that the rule of law applies equally to everyone. Meanwhile, political opponents are likely to highlight the ruling as evidence of accountability and transparency in government, emphasizing the importance of following established legal processes. Ultimately, the Supreme Court has revealed a previously unknown legal process that has been ongoing for over a year. The case now demands the submission of documents related to financial records, international communications, and other relevant evidence. The outcome of this process will have far-reaching implications for both politics and public perception. Authorities have requested documents related to potential international election involvement. Compliance is required within 72 hours, with failure carrying serious legal consequences, including possible detention. Trump reportedly reacted with shock. His legal team was unaware this ruling was imminent, leaving his organization no time to prepare a strategic response. The scope of the subpoena suggests investigators are examining actions far beyond what has been publicly disclosed. After a year of private legal battles, Trump's defenses have been exhausted. At this point, there are no additional procedural options, and any attempt to delay or resist could trigger severe penalties. Every eye is now on the coming 3 days. Will Trump comply providing the requested materials, or will he risk legal consequences for defiance? The outcome will reveal whether information he has kept confidential will finally enter public view. A former president is now operating under the full authority of the Supreme Court with no further avenues for appeal. Uncertainty has reached unprecedented levels. The clock is ticking and the stakes could not be higher. Regardless of what these documents contain or what Trump has sought to conceal, the nation is about to learn the truth. This is a critical moment unfolding faster than anyone anticipated.